Good morning, Mr. Anderson.
Good morning, sir.
I want you to sit back and relax.
Yes, sir.
I I have a presentation, plus I have some questions, okay?
Yes, sir.
Good morning, Warden. How are you?
Good morning, Mr. President. Doing good. Thank you.
Madam Chairman, we have Kirk Anderson, POC number 126-29. He's currently 55 years old. He's been incarcerated for 29 years of an 83.5-year sentence. He's only served 35% of the judge's sentence. He was on parole at the time he committed the aggravated forcible rape and related charges. Tell this panel, Mr. Anderson, exactly why you were convicted and are serving time for these offenses. What did you do?
Well, I committed a rape on a woman that I went to meet at her house at 12:30 at night. We was meeting, and I committed a rape on this young lady. I committed a rape on her.
And you go to a cousin's house and invited her outside. Am I correct?
Yes, sir. We left, and I walked her back to the.
And you dragged her to a vacant lot and you did all kinds of sexual acts upon this individual by force. Am I correct?
Yes, sir.
So tell me why I should vote to release you today based on the time that you committed and the time that you've served. You've only served 35% of your sentence. Tell me why I should release you.
Well, sir, first of all, the individual that committed those crimes is not sitting before you today. I've went through everything that I can do to change my way of thinking, my way of calculating, my religious beliefs, everything. I never had those systems before. I was a young guy when I committed those crimes. I understand there's no excuse for that. And I apologize to the victim over and over every trial I make. And I understand how graphic that situation is, but the person that committed those crimes don't exist at all sitting here with you today. And I've been incarcerated longer than I've been free in the free world. I was 25 when I committed those crimes. I'm here 29 years. I've been out longer than I ever been free.
Thank you, sir. Mr. Anderson,
Yes, sir.
did drugs or alcohol play any part in these offenses?
Well, I've never been a addict. Well, she was drinking.
Yeah.
She was drunk.
Sir, yes or no? Did drugs or alcohol play any part in this offense?
No, I was in my natural mind. I did that with my own will, free will. Yes, sir.
Thank you. Have you ever used drugs or alcohol?
Have I ever used alcohol? Yes, sir.
Have you ever used illegal drugs?
Well, I done smoked weed before. Yes, sir.
And when was the last time you used any illegal drugs?
When I was in college, about 20, 22, 23.
So you're telling me in the last 30 years you have not used any illegal
Not one
drugs?
time. Not one time.
Thank you, sir. Let's talk about some of the programs that you completed. Give me 1 second. I see where you completed all 4 phases of your sex offender treatment.
Yes, sir.
Tell me exactly what you got out of the sex offender treatment that you didn't know before you committed the forcible rape.
Well, I didn't know the 7 sexual disorders. I didn't know the Roker scale, what the assessment, and the Roker self-assessment scale. I didn't know that. I didn't know a lot of risk The fact I didn't know him. So when it's out, I didn't know the sexual cycle. I didn't know any of that. And I became the facilitator after learning it.
And that was before the feds and the sex offender, and you were
Yes, yes, sir. Yes, sir.
Take victim awareness.
I couldn't hear you.
Did you take victim awareness?
Well, I took that in Camp D before I was transferred to the main prison when I did my other courses. I took that. I took hours of victim awareness. Yes, sir.
So exactly tell me what you did and how did it affect you knowing what the victim was doing?
I thought about my children. I have 4 daughters. I thought about my daughters, and if I know how I would feel if something happened to them, and I know that's there's no excuse for what I've been having myself for 29 years with this. This is not me. This is exactly what I did, and I understand it, and I hammer myself every day. This is not this is something I'm ashamed of. Even be presented with this. I don't.
Excuse me, Mr. Warren.
Yes, sir.
Fine. The audio is going in and out. Audio is going in and out. Can we see if you can set the audio?
See, that's why I can barely hear him question.
Let's try that.
How about that, Mr. Roy? Can you a little better?
Yes.
Y'all is kind of doing the same thing.
It might be a connection issue.
Can you hear me?
Yes, sir.
Yes, sir.
Now,
Okay. You've also completed 100 hours pre-release, life
Yes, sir.
skills, education, living in balance. You didn't have a substance abuse problem, but you finished living in balance parts 1 and 2. Is that correct?
yes, sir.
You've completed CPR training, thinking for a change. Tell me about manhood training. What was that about?
I couldn't hear you.
Manhood.
I see
Manhood
that
training. That was manhood training was about skills to deal with your children and everything that a man would need to be a man if he was released, if you have kids, and if you the problems that you're facing, how to think before you go into something, and how to take a man instead of a kid that most of us come penitentiary as youngsters that really couldn't think right. It's teaching you how to be a man, all the things you did. Everything that a man needs to be a man, that's the whole program.
Okay.
Enjoy the mental part, then.
Also completed personal development, parenting classes,
Yes, sir.
and value clarification. Any other programs that you'd like to mention?
Well, I took some parenting classes and some character counts classes, and that's about it. Oh, anger management, I took that too as well.
Tell me about any organizations that you participate in.
Organizations. Well, I was in the Islamic community for years, and I taught a class with the Islamic community. That's what I was part of the whole time. Basically, I've been in touch with the Islamic community, and the young men's program that was my brainchild, and I taught that class for several years at Camp D,
Okay.
and that's basically what the organization I was part of.
Okay, what is your job at the facility right now?
I couldn't hear you.
What is your job at the facility right now?
Well, I just came here about a month and a half. When I was transferred from Angola, I lost my job and it was due to being transferred. Lost my job, my trust. I was a trustee as well. I lost that for being moved from Angola to Rangola. I was just trying, I just protocol with the transfer.
Basically, they lose your job, you got transferred.
Yes, sir.
Or did you lose your job before you were transferred?
No, sir. I'd have no disciplinary action. And I just, by me being transferred, I had to start from the bottom at this institution.
Okay, okay. Do you have any vocational skills?
Yes, sir. Carpenter.
You're a carpenter, okay?
Yes, ma'am. Yes, sir.
Do you have any job-related certifications?
Yes, sir. With
And what
carpentry? And carpentry.
Okay. You have 22 disciplinary write-ups and 29 years of incarceration. The last one being on September 24th, 2017, and that was a number 10 for fighting. Tell me about that.
Well, a guy didn't want to be in Camp D, and he punched me on camera. That's why they didn't lock me up, and they didn't do me anything about it, because he wanted to move to Camp D. And the way you do that, if you punch, you get into it with somebody, you're gonna have to move one of y'all, and that's what happened.
Questions? You
Yes,
pleaded
sir.
guilty. Pleaded
Yes, sir.
guilty,
Yes, sir.
but you
Yes, sir.
refused to sign the disciplinary write-up. Why?
I didn't refuse to sign it. Well, if they got it down there, I refuse to sign it. But I pled guilty because there was a zero tolerance thing with fighting and ain't going at the time. There's no way you was gonna win, no matter if you didn't start or not. If you fought, you fought. But they didn't lock me up.
You did not, and you were not sent to extended lockdown or the working cell block.
No, sir. I kept my job and went, and I was a trustee. Kept my trustee status. He did it in front of the warden on the camera.
Okay, let's talk about your transition
Yes,
plan.
sir.
I see that you're gonna live in Hammond, Louisiana.
Yes, sir.
And you're gonna
Hammond.
work in either Baton Rouge or Lafayette. Which one?
In Baton Rouge. That's the Baton Rouge. The whole plan was Lafayette.
Okay. Opposition in this case comes from the DA's office in Jefferson Parish, law enforcement in Jefferson Parish, law enforcement in Orleans Parish, and multiple victims are adamantly opposed to any early release in your case. Mr. Anderson, you remember what I wanted to do, Mr. Anderson? Remember, today's hearing is not all about you. It's about the victims and their families. It has been 29 years, but the victims are still physically, mentally, and emotionally affected by this horrendous crime. We actually went over to a house, took a female outside, dragged her by her neck, and physically and sexually assaulted her at your will. And this victim is still under medical care. So today is not just about you, it's about a victim and her families. You have letters of support, and you have numerous letters of support, and letters come from Sean, Damian, and Tara McAllister, Larry and Julian. And give me 1 second, I have to go to another page. You also have letters from Helen LaSalle, Reverend John Mosley, Mrs. Dampier, Beverly Bovis, LeVon Williamson, Malik Become, and many, many other letters of support. We have many programs and faith-based. And would you like to mention any other achievement program, organization that you especially fond of?
Well, the parenting is most so because I didn't get a chance to be a father to my daughters. They grew up without me. But like I told you, victim awareness is an emotional thing with me because I know exactly what you're saying. I understand what you're saying, and I know that this traumatized this lady. I know, and I understand that, and I, like I say, every time I make my prayers, I ask God to forgive me, and I ask the victim to forgive me, and because I have daughters, I wouldn't want that to happen to my kids, and I understand that. But like I said, I'm not the same individual. I done did everything a man could possibly do to enhance himself in every possible way. I understand, but I understand what you're saying. Yes, sir.
Mr. Anderson, you stated that you had 4 daughters.
Yes, sir.
I'm just interested in knowing how you explain your crimes to your daughters once they reach the age of adulthood and became young ladies. How did you explain your offenses to your daughters?
When they got old enough to be able to handle, I told them the truth. They know, but they came to every hearing that I've been to, and they heard they heard everything. I said it to you before, and they heard me telling you, but they knew already. They know, but I was just trying to tell them how I was and how to stay away from people like I was thinking. I care about my daughters just like, and I know I victimized the community. I victimized the lady's family. I understand that, and I know I did. And I can't change the past, but I try to do anything I can to stop that from being in my daughter's mind as far as who I am. I try to change everything about myself for them, and and like I say, I apologize, and I ask for forgiveness from God, and that the lady forgive me for that because I was
Thank you, Mr.
young.
Now, Warden Turner, I'm sorry, I'm still at DCI. Warden Meyer, would you like to make any comments, remarks, or observations at this time?
I'll call Warden Turner after this is over with and tell him you complimented him today. Yes, sir, Mr. Roger. Mr. Anderson hasn't been with us very long, as he spoke to. He's only been with us about 2 months, so I really don't have a lot of knowledge about him. Only just looking through his record and the conversation that I had with him yesterday. He has taken some good programming. It seems like he paid attention in it. He learned some things from it, and one thing that I will commend him on is he takes ownership for his crime. He takes responsibility. He understands what he did was wrong, and he shows remorse. So that's the one thing that I will say that I do appreciate from him. He hasn't been here long enough to be a member of our Strive program or anything like that, and we talked about that yesterday. And if he is denied parole today, he's assured me that he's going to work towards that and do everything here that he needs to do to continue to try to better himself. But he's on the right track and he's doing the right thing. I do think he's a different person, again, not taking anything away from the seriousness of the crime he committed.
Thank you, Warden Meyer. Madam Chairman, I have not made a decision on Mr. Anderson yet. I will sit back and listen, and then I'll make a decision at the appropriate time.
Thank you, Mr. Rocha. We'll hear from those who've indicated they want to speak, and we'll start with your cousin, Hanif. Sir, I'm sorry, I can't pronounce your last name. Would you pronounce it for us? You're on mute still.
Hello?
Yeah.
Is Honey Futa also known as Frank Julian?
Okay, go ahead, sir. What would you like us to know?
Okay, well, I'm speaking on my cousin's behalf. We thank you all for giving us the opportunity to speak this morning. As things have already been said, you know, he's completed a lot of the programs that's required. But what goes without saying is the fact that he have not had a write-up in several years, at least 5 years, which reflects a sense of spiritual consciousness. And I think he's on the path of rectitude and spiritual development. So as he's developing like this and appeal to the board, I would say that it would be best to give him an opportunity to reestablish himself with the family and society to continue their spiritual development. Otherwise, you know, if you continue to be locked up, that may inhibit his spiritual development. And then we get into what we call overkill. So I think it would be best for himself and the family, and perhaps the victim's family, to be given another opportunity to express himself in society as a productive citizen. We know the fact that, as he said, things that happened in the past he cannot undo. He's not the same person. So I'll just speak on his behalf in terms of giving him opportunity to continue his spiritual development for himself and everyone in general.
Yes, sir. Thank you so much. We'll hear from Mr. Henderson now.
Good morning, members of the board. I am here on behalf of Kirk as a family member, not just a family friend, but also Hanif is one of my spiritual advisors. And so being a part of the Islamic community, when Kirk was talking about the things he's done, he helped guide a lot of guys while we were in Angola with the Young Men's Program to kind of like bring them in out of the rain, to kind of like get them out of harm's way. And throughout his whole incarceration, that's all he's been doing, is trying to give back. And you know, one of the things about the particular crime is that, you know, the crime is shunned on even inside the prison. You know, and so balancing, trying to maintain the conduct record that he needed, given the fact that he did, and he wound up primary in D for a while, because primary Camp D at that time was kind of like the place where they would send most folks who were either charged with that or were kind of like in protected custody, so to speak. And so he had kind of like really not only grown in age, but his maturity, you know, because like I said, again, I know when he first showed up, and been kind of like, because of my relationship with the family, has been kind of like monitoring everything that he does. And I am just hopeful that, and I heard Mr. Roche say about the opposition from the local folks here in New Orleans and Jefferson Parish, but I want to remind that his transition plan is to actually move to Baton Rouge, to kind of like take him away from the environment that created this problem for him. He has a loving family, the daughters he speaks about and talks about. Everybody's here just kind of like trying to see what we can do to help him in the event that he's blessed to be granted parole. And so I'm just hoping that the board would take into consideration all the things that you've done. I mean, even his limited time where he's at now, that he's been productive. And being candid about the questions that Mr. Roche asked him. And, you know, and I'm gonna say this, and it's not to kind of like say anything about the other men, but when Mr. Roche investigates somebody, Mr. Roche is like CSI. You know, he leaves no stone, I'm serious, he leaves no stone unturned in the sense of bringing out the things that need to come out. And it's really beneficial and advantageous even to the family members who are listening, because it gives us a sense of, oh, I didn't know this particular thing. And so I'm really helpful and grateful that Mr. Roche interrogates people in the manner in which he does, because it makes it easier for us on this side to make decisions also about here I go, here I stay. So I'm just, you know, prayerful this morning that the board would really consider Kirk for release. Thank you.
Bobby Wiley.
Good morning. My name is Bobby Wallace. I want to first thank God and the board for the opportunity to speak on behalf of my brother, Mr. Anderson. I've been knowing Mr. Anderson for over 30 years. I also spent 22 years and 4 months in Angola. We have a personal relationship. And what impacted me the most about Mr. Anderson was the Young Men's Club, the Young Men's Organization, because it was not only limited to the Islamic community. He reached beyond that, and he touched me. I knew him when we were ignorant young boys on the street to mature men in prison. And Mr. Anderson would be an asset to any community that he's released into. And if there's anything that I can help him out with in his transition, because I am aware of the things that await us out here after so long, I would walk him step by step as much as I can. And I think that Mr. Anderson is an antidote. In order to be an antidote, you have to be the poison. He got over that poison stage. He's an antidote now. And the community needs people like him. Thank you and God bless.
Thank you. Okay, Mr. Anderson, is there a statement you'd like to make to the panel to wrap it up for us?
Yes, ma'am. I would just like to apologize again for the crime I committed in 1993. And I'm remorseful because like I said, I have daughter. I wouldn't want that to happen to him. And I know that victimized the whole community and the family. I victimized my own family with my decision back then. My daughters grew up without me, but like Ms. Rose said, this is not about me. It's about the victim.
Go ahead.
Okay, but yeah, but I know I victimized that whole family. That's all I wanted to know. I just wanted to leave it a note that I'm thoughtful about what I did.
All right, well, thank you, sir. I think
Yes,
we're
ma'am.
prepared. And we're going to, Mr. Roche will be voting first.
Mr. Anderson, I thought long and hard. And I've listened to the warning. You've only been there a couple of months, but I think you had some hope that you're a different person and that you're clean disciplinary record for the last 5 years. Goes a long ways to tell me that maybe you turned the corner. You have related to me some of the information that you got from various programs. So we're not only attending the program, but you were listening to the information and applying it yourself. Because when I asked you about sex offender treatment, you said you thought about your 4 daughters. And you wouldn't want that to happen to one of your daughters. So you've given us some thought. Based upon your programming, you've completed all 4 phases of the sex offender treatment. With the social service, in young men's club, good programming, a low risk assessment score. I'm willing to give you an opportunity to prove to this panel, your family, and everybody else that you can become a productive member of society. So I'm going to grant your early release this morning with the following conditions. That you have a curfew, 9 p.m. to 6 a.m. Without for any reason, legitimate reason, after 9 o'clock at night, church, work, you must get that approved by your parole officer before you can be out after 9 o'clock. You understand?
Yes, sir. Yes,
And I
sir.
want you of community service with the at-risk youth. There are a lot of young people out there going in the wrong direction. You have the newspaper, you have TV, so you know what's happening on the outside.
Yes, sir.
There's a lot of young people in trouble. I want you to get with your pastor. I want you to get with your law officer. And I want you to talk to disadvantaged youth and try to steer them in the right direction.
Yes, sir.
That is my vote.
Thank you, Mr. O'Shea. Mr. Freeman.
I thought long and hard about this case, but I'm gonna go along with my colleague, Mr. Roche, with the same condition. Vote to grant.
Thank you,
All
sir.
right. Mr. Anderson, I struggled with it too. It's a horrible crime. It's still terribly affected by it. But based on your family support, your transition plan, and the community service work that you've done in the prison community, I'm willing to take a chance. My vote also is to grant it, with the added special condition that you have absolutely no contact with the victim or her family.
I couldn't hear you.
No contact.
No contact.
Yes, ma'am. Yes, ma'am. Yes, ma'am. Yes, ma'am.
All right. Good luck to you, sir. Thanks, everybody who participated. Warden, that concludes our business at your facility. We'll adjourn. It's 9:36.
Good day.
So,
Vote, man.
Well, as you can see here, the warden gives him a firm handshake and kind of says, like, man, you better do well out there. And I don't know what to tell you, but he's locked up again. And I don't know if the low risk scores could have ever thought this might have happened, but it wasn't for an offense of a sexual nature. It was for a DUI, which happened actually just about a month ago, November 11th, 2023. So he gets out about July 2022 and goes a little more than a year. And I suspect that we're going to see a revocation hearing. And when we do, we'll play it for you. I don't know when it's going to happen, but I mean, he's back and his good time is 2070. So he was locked up for 29 years, got a little bit taste of not being locked up, and he's back in pretty much a life sentence. And I don't understand how someone can ever get in a car, do anything wrong. You're back in a life sentence. And anyways, to this hearing, we have information. Thank you, Richard, for all of this. And when you see this information, it just seemed like a bad interview. I thought Roche could have handled it better. He kind of just cut him off and didn't let him talk his way out of parole, because it sounded to me like he was fabricating the reality, and Roche more or less jumped in and said, well, you dragged her to the parking lot, but who knows what story he would have spun if that didn't happen. So Kirk Douglas is his first and middle name, which is quite a choice there, was charged with forcible sexual assault, second-degree kidnapping, and aggravated crime against nature. He was found guilty as charged on all counts and adjudicated a multiple offender. He was sentenced to 80 years at hard labor without the benefit of probation, parole, suspension, a sentence as a multiple. Do you hear that dryer? It's driving me nuts. You know what else drove me nuts during this hearing? The sound going in and out. That was quite annoying, right? Where was I? Okay. He was sentenced to serve 75 years of hard labor without the benefit of second-degree kidnapping benefit. 15 years in hard labor benefits of aggravated crime against nature, all sentenced to run concurrently. At the time of the incident, the victim was staying at the apartment of her. So here we'll get into what actually happened. At the time of the incident, the victim was staying at the apartment of her cousin and her cousin's boyfriend. Her cousin used the bedroom and the victim slept on the couch. Late on the night of February 14th, 1993, the victim received a call from a male friend that she had known for about a week. He told her he was coming over to visit. When he arrived, Mr. Anderson, who was his cousin, was with him. The victim and the two talked for a while. Mr. Anderson asked the victim to step outside with him for a moment, which she did. It's unbelievable. How does that even happen? So she steps outside and he then grabbed her by the neck and dragged her away. The victim's friend started to intercede, but stopped when Mr. Anderson threatened to kill her. The friend then called the police to report a kidnapping, possibly involving a weapon, and gave the police a description of Kirk Anderson. Can you imagine? I mean, this is a whole different. He this should have been brought up because, like, you do this in front of someone, it I, it adds a different level of nutso to it because you're gonna get caught, dude. What? Well, I don't think we've ever seen anything like that. Um, the friend then called the police to report a kidnapping. Okay. Officer Lisa Williams, who responded to the call, went with Mr. Anderson's cousin to look for Mr. Anderson and the victim. I wonder how long it took for the police officer to get there, though. And think about that. Imagine you're kidnapped. You feel completely safe. You're there with people. You're there with a friend. You're in front, and the person grabs you, and that's it. And who knows? It could have been the police could have taken an hour to get there. Considering the nature of the offense, the victim's name is not used. Okay. Meanwhile, Kirk Anderson dragged the victim to a vacant lot with overgrown grass and reeds and proceeded to force her to perform oral. Face to face. I don't. Okay. I guess they're talking about different positions. Face to face and intercourse from the rear. During the intercourse, he told the victim he had been waiting to F somebody. Hold on a second. Okay. After Mr. Anderson finished, he asked the victim if she would tell anyone, and she assured him she would not. They then walked together back to the apartment where the victim was staying, but no one answered their knock. Mr. Anderson left, and the victim knocked on the door of someone else in the building who let her in. What do you think? Like, oh yeah, whatever, I'm just gonna get away with this. Investigating officer Detective Joseph observed a fake fingernail by the front door of the apartment, which apparently torn from the victim's finger as she was forcefully taken away. Officer Goins also observed scratches on the victim's arms, legs, and back. The examining doctor found bruises on the victim's neck and scratches on her legs and lacerations to her vagina, which was consistent with the history presented and with non-consensual intercourse. He further found semen in the liner of the victim's undergarments. Okay. Detective Goins obtained a photo lineup which he presented to the victim, who positively identified Kirk as her assailant. Mr. Anderson was arrested 3 months later at his home in Baton Rouge. Why did it take 3 months? Someone doesn't just do this once. You have to I'm assuming that you would think to be comfortable to do this. And he claimed he was sober too at this hearing. That you have to have done this many times. I mean, Mr. Anderson admitted that he was the person who left the apartment with the victim and further admitted to oral and vaginal intercourse. However, he said that it was not only consensual, but that the victim came home to him. He suggested that he had been set up by his cousin, of whom he had gotten the better at an altercation a week prior to the incident. He admitted that he did not turn himself in, even though he knew the police were looking for him. On cross-examination, Mr. Anderson admitted that he was on parole for armed robbery, to which he pled guilty, but denied that he was guilty of that offense. A review of record for patent error indicates that the motion for new trial and judgment acquittal was standing prior to. So now we're going into the whole appeal. And he said his attorneys were ineffective. That's the classic what you do when you have nothing else to do. In the instant case, defense counsel failed to pay sufficient attention to the answers of the prospective jurors, which they questioned the district attorney as a result. To think he was on parole for armed robbery. I wonder how the parole board feels about that. So here's listed in the appeal. Actually, something kind of interesting. Well, no, it just zoomed up on me. But he's appealing many different things, and here is something that actually he might have a point on. So he says that his attorney failed in, hold on, let me find the spot. Okay. Here. He claims that his trial counsel was ineffective in not challenging a juror who admitted that her daughter had been sexually assaulted. He also claims that he was prejudiced because the counsel asked this juror if she could find Mr. Anderson innocent as opposed to not guilty. The issue of the juror's presence on the jury was decided in the original appeal. This court found that there was no error in allowing her to remain on the jury. The determination has become final. Man, so like, I mean, how? Normally, yeah, his attorney should have made sure that she was not on the jury stand. That's like a no-brainer, in my opinion. So, but it's kind of funny. The courts in these appeals just kind of do whatever they want. They're like, nah, it's okay. Mr. Anderson also complains that counsel was ineffective because he did not properly oppose the state's motion in Lamine to preclude testimony concerning the victim's sexual history. So he wanted to victim blame here, but let's see what he meant. This motion was heard in chambers, and there's a transcript sufficient to dispose of this claim. So do they talk about the claim? So they went into the judge's chambers and they discussed this. Trial counsel indicated that he would introduce evidence of the victim's alleged habit of exchanging sex for narcotics. Okay. So they wanted to say that she was selling herself. The state objected based on Code Evid Art 412. The trial court correctly sustained the motion. Okay. Even if she did do that, who cares? You didn't, that wasn't the transaction you had with her. Louisiana Code evidence basically provides that only time a victim's prior sexual history is admissible is if the defendant wishes to demonstrate another possible source of, or injury within 72 hours of the crime charge, or that the victim had sexual relations with the defendant on prior occasions. Because Mr. Anderson did not wish to introduce his evidence for either of these purposes, it was inadmissible. There was well, I guess he should have just made it up that he had then, huh? There was no error in the trial court. Isn't that interesting? If he would have stated that they had done it before, and then they brought that into evidence that she had done this, maybe he would have swayed the jury. There was no error in the trial court's ruling in this, no prejudice in Mr. Anderson. It's just funny. Once you know the law, you can mess around. In the last issue brief pertaining to the ineffective assistance of counsel claim, Mr. Anderson alleges that the counsel failed to request a toxicology report of the victim. Review of pretrial discovery filed on behalf of Mr. Anderson reveals that his counsel requested inspection and or copies of any reports of physical or mental examination and of scientific tests or experiments intended for use of trial. The state responded to the request, and there is no indication in the record state that failed to respond to discovery. And that was it. But yep, he's back locked up, and maybe we will get a revocation hearing soon. But I don't know. Man, they're not going to be happy. They are not going to be happy. Mr. Anderson was previously convicted of armed robbery. He and a co-conspirator armed with a knife and gun robbed a woman of her automobile. You're so brave. You have a knife and a gun. Go take her car. Great. As noted by the trial court, Mr. Anderson pled guilty and was sentenced to 7 years. That's all he got. 7 years for using a knife and a gun to steal a car. He was released on November of 1992 and was committed committed the present offense on February 15, 1993. And then he gets out and he gets a DUI. It's like, man, you just want to live in prison, huh? The evidence introduced at trial revealed the victim was seized by her neck, choked, and dragged to a nearby vacant lot. Okay. I think we've gone through this already. At trial, Mr. Anderson showed no remorse and contended he was innocent because he and the victim engaged in consensual sex. In sentencing, Mr. Anderson and the trial court recognized the severity of harm inflicted on the victim and that the sentence imposed was intended so that Mr. Anderson would never have the opportunity of inflicting such harm on another person. Yet he did get into a car intoxicated. The court also correctly noted that Mr. Anderson engaged in these criminal offenses only 3 months after being released from prison and the prior offense. In light of the circumstances of the present case, the trial court did not abuse its discretion and sentenced the defendant 8 years at hard labor, 80 years at hard labor without the benefit of parole. So you might say, well, how is it that he has parole if he was sentenced to 80 years without parole? And that's because of Act 122, the Louisiana Parole Project, which lobbied to pass that legislation. They lobbied hard, more money in their pocket. But anyone who served more than 25 years of a sentence and is above the age of 40 can now be eligible for parole. Thank you, Richard, for the research. And we can jump to the next hearing that Richard wants us to see, which I haven't seen yet.
Rambo, Deputy Warden.
Anne Marie Easley, Assistant Warden.
Reginald Admiral classification.
Carmen Shipley, Offender Records.
All right, that's everybody. Good morning, everybody. And we have before us Mr. Girolamo. Sir, is that you? Mr. John?
Yes,
Would you introduce yourself to the parole panel? Tell us your name and your DOC number.
my name is John D. Girolamo, 89764.
All right, and you've heard the introductions, Mr. DiGirolamo. I want to recognize you are represented by counsel. I'd like to ask your counsel to introduce herself for the record.
Yes.
Good morning, Ms. Renatza. Jane Hogan here with the Louisiana Parole Project, appearing on behalf of John DiGirolamo. With the committee's approval, I'll make a statement at the end.
All right, thank you very much. I'd like to recognize the others who are also here joining us today. We have Mr. Andrew Hundley from the Parole Project. We have Danny Bates, a nephew, who will be speaking, and also Shannon Bates, who will be speaking in support. We also have some folks here in opposition. We have a representative of the DA's office in St. Tammany. We have with him, we have representatives from the victims. We have Ms. Anisha Reese, Renee Garrett, Gail Schlosser, and also Donna Andrews from the Attorney General's office, all of whom will be speaking in opposition. First, Mr. DiGirolamo, I'll read some identifying information into the record. I'll ask you to verify that information, and then I'm going to turn it over to Mr. Pete Freeman. Your case has been assigned to him, so he'll take the lead on the interview. All right?
Okay.
Once we've heard, we do the interview, we'll hear from the folks there at Angola and everybody who's indicated they'd like to speak. Before we turn it over to Ms. Hogan, you'll be allowed to make a statement if you'd like.
Thank you.
You are John DiGirolamo. You're classified as a second felony offender. You were sentenced in August 1979. Armed robbery, you received a 99-year sentence. Attempted first-degree murder, 50 years. Second-degree murder, you received a life sentence. And then that was in St. Tammany. In Orleans, you have a sentencing date December of 1979 for aggravated kidnapping. You received a life sentence. So you're currently serving a life sentence. You do have a parole eligibility date determined to be August 1st, 2020. You're not eligible to earn good time. Is that information correct?
Yes, that's correct.
All right, Mr. Freeman.
Okay, I'm just calling you John, Mr. John. How long have you been in prison?
Almost 45 years.
And okay. And how old are you?
64.
What's your educational level?
I'm attending literacy school. I have about an 8th grade education.
All right. Tell me a little bit, we've read the arrest report. Give me a brief synopsis of what happened on that evening when you kidnapped that couple in New Orleans.
Everything happened so very fast. It was a spur of the moment thing. We never went out with the intent of really hurting anybody. I have a fall partner who is older than I am. He was armed with a gun. We had a stolen car. Our car broke down and we was in search for another car. We walked into the city park in New Orleans where we found 2 people in the front seat. My fall partner ordered for them to get out the car and we needed their car and we took them along with us. Their car broke down and we didn't know what to do with them at first. And my fall partner walked them to the woods. I was right behind them. And we figured if we let them go, they were going to say something. So we shot both of them. And after he shot them, we walked off. It was only moments later, we were surrounded by police. And I think it was like 2 days later, they arrested us in Slidell in a motel room.
Right. Right. Have you taken any victim awareness classes?
Not directly. They told me I didn't need that because I didn't have a sex charge, but I have other certificates. Thinking for a change, 100 hours pre-release. I was a tier walker at Camp J for many years. I'm attending literacy school. That's about it. They told me I didn't have to take victim awareness since I didn't have a sex charge.
Okay. Well, victim awareness is a good class because, I mean, you obviously affected a ton of people by the crime you committed.
Yes.
If you were able to talk to the victims, which you're not, but if you were able to tell the board what you would say to them with regards to this instant offense.
Well, I would tell the victims' families that I'm very sorry for the crime I committed. I was a very rebellious child. I was from a family that was full of corrupt, and I just wanted to be somebody I really wasn't. It turned out really bad. I'm sorry for the crime I committed. I live with that every day. If I had a chance to bring him back to life, I would.
I would never make the same mistakes again that I made when I was a juvenile. I'm fully grown now. I understand what I did was very wrong, and I would never commit a crime ever again in my life. I'm just very sorry for what I did, and I apologize. Sometimes an apology is not always good enough, but I'm a different person than I was when I was 17 years old. I'm fully grown now. I'm drug-free. Um, I'm just very sorry for the crime I committed, and I really appreciate the state of Louisiana for giving me this opportunity to start all over again. I'm almost 70 years old, and I'm fully mature, and I don't make mistakes like I did when I was 17 years old. Tell I'm me, very tell me a sorry. little bit about your childhood. Did you come from a good family? I mean, you ended up on the road at 17. Yeah, I did a lot of running away. I didn't want to listen to my parents at all. I had a good mom and dad, but my dad was full of crime himself. He was corrupt. Uh, I just wanted to be somebody like he was. He tried to help me out, but I was very rebellious, and before you know it, I was in jail for the rest of my life. But basically, I was from a good family. I was just a terrible kid. Did you have a drug problem back when you were on the streets at 17? No, not really. I never really used hard drugs except for marijuana and amphetamines and barbiturates. As far as the hard drugs, I never experienced them. Okay, what about alcohol? Never a drinking problem. So I alcohol don't wasn't even, involved. I don't even think I even tasted a beer. I don't remember drinking alcohol at all. Uh, you have law enforcement opposition, which is expected, very strong law enforcement opposition. You have a niece that's unopposed and has offered you a place to stay. Tell me about this place that they're offering you to stay, and what would you be doing over there? I understand they have a farm with horses on it. It's away from any major cities. Um, I was told that I don't have to work, but I would like to try to do something to make up for all their generosity, love, and understanding. I just don't want to just lay around. I would like to do something to show my appreciation for all they have done for me since they entered my life. Um, I'm not going to go nowhere by myself if I am granted a parole. Um, I take full responsibility for whatever actions that happen. I'm very grown up now. I'm not the same person I was when I was 17. I think it's a great opportunity for me to live with them. I love them very much, and they love me very much, and I really appreciate them coming into my life and giving me a second chance. I would never, ever do anything as far as committing crime again. I don't want to hurt them. They're beautiful people. They have two beautiful daughters. I would like to be a part of their family and live with them. Whatever I could do to help them, I will. I'm definitely not the same person I was many, many years ago at the age of 17. Um, I'm not a violent person, even though I was a part of a violent crime. Um, it'll never happen again. I don't even intend to jaywalk. No crime at all has entered my mind. Um, I just want to be a part of their lives and try to make up for what I did. I would like to have some type of community service to where I can talk to other older people, younger people about drug addiction and the possibility of ending up in jail like I did for a long time. I'm very sorry for what I did, and I'll never do
Oh,
anything again.
Talk about that at the end of your interview. We'll give you a chance to make a statement. What classes have you taken? I know you took a 100-hour pre-release thinking for a change. What other classes you taken, and which one has had the greatest effect on you?
Thinking for a change had a real big impact on me. Anger management also, 100 hours pre-release. But the most effective class that I went through was thinking for a change. It taught me how to think before I act, whether I'm angry or not. Thinking for a change made me realize it's best to think before you decide to do something. Anger management, another name for it was raise your cage. And it taught me to have control over my hostilities, which it was a real big impact on me. I watched plenty of videos of people that had behavior problems, and it seemed like they had a lot more behavior problems than I ever did have. I learned very well about thinking before I react. And it taught me how to be more responsible, and it taught me to be more mature. And I'll never make the same mistakes I did when I was younger.
Okay, let me ask you this. I see you in a wheelchair and you've been to the hospital
Yes.
several times. What kind of ailments you have right now?
I have several. I have a very bad back. My vertebrae touching the nerves. Late last year, I had 2 strokes back to back. I was treated at Lady Lake twice. I have permanent no duty. I cannot walk on my own. Um, I'm just in really bad shape, my back, and they said that I could have another stroke if I don't be careful what I eat. And the right side of my arm right here is still numb, and I have problems moving it. I'm confined to a walker. I most of the time I'm sitting down. I have trouble walking on my own, and that's why I have a walker.
Okay. Over your 45 years, you've had 93 write-ups. Last one was back in 2020. That was an unauthorized area. But back in 2018, you had several in one day. What led to those write-ups in that one day?
The last write-up I had was unauthorized area. I was coming from a call out, and I had to use the
And I'm
bathroom.
not worried about that one. I'm asking about 2018, February 7th, 2018. You had a contraband, disobedience, and disobedience aggravated. Looks like it all happened at the same time. What happened that day?
I was on a strong medication called Bacafins, and it made me like where I couldn't control myself. I was 100 milligrams a day, and they written me up for contraband and intoxication because of the Bacafins. They thought that I was on some type of drug, but in all reality, it was the strong medication I was prescribed because of my back.
All right. It does say low, like play it down. Okay. I have no further questions, Mr. Knox.
Warden Ambo, can you add anything?
The only thing I can add is that the victim awareness class that he said he wasn't afforded, I couldn't see it being not afforded because of him not being a sex offender, because he did have victims. Other than that, the report that he had that Mr. Freeman asked about, for intoxication and contraband was the fact that they had found a green leafy substance and they said it was mojo that he had smoked.
All right, thank you. Appreciate it. I have, Mr. DiGirolamo, I have, just want to ask you a question about your health issue. You mentioned your back problems. What, is that due to an injury?
Excuse me?
Back issues, is that due to an old injury?
Many years ago, I used to lift weights and, I used, the form I used was, not correct. And I ended up injuring my back over the years. And, that's what I'm suffering from right now.
Okay, all right, well, thank you, sir. We'll hear from those people who have indicated they'd like to speak. First, we'll hear from the Parole Project, Mr. Hunley.
Andrew Hunley with Louisiana Parole Project. I've first met John in the 90s at David Wade Correctional Center. Everyone called him Geronimo because they couldn't say his last name. So I promise that people here today aren't the first people who've had a hard time pronouncing his name. Obviously, the board's aware that his reentry plan does not have him staying in Louisiana. His reentry plan that he is requesting is to go to that out-of-state plan in Texas to live with his family and not to return to Louisiana. Since the Miller and Montgomery decisions, there have been approximately 100 juvenile lifers who've been released. As this board's aware, juvenile lifers have had great success when given second chances, and juvenile lifers don't account for a recidivism problem that's going on in the state. This board has granted some juvenile lifers to out-of-state releases to not return to Louisiana. In those cases, Parole Project works with the families to identify reentry support in the areas where they will return to. I'm here to tell the board today that Parole Project commits to working with Danny and Shannon, who John would live with if released, to identify the reentry support resources that are available in their area. Also, just like to comment from my interactions with John, I can tell you that John not only has physical disabilities, but cognitive disabilities. I know there are many things that this board considers as it pertains to whether they give a person release or not. As far as a public safety issue, I can tell you that John is certainly not a threat to public safety due to those physical and cognitive disabilities, and he'll need support from his family that he would live with if granted release. He is certainly a strain on the staff at the prison where he's at because of the disabilities he has, and Parole Project's committed to assisting him and his family with his reentry plan if he is released. Thank you.
All right, thank you, sir. So we'll hear from the Bates. I'll let you decide who goes first.
Hi, I'm Shannon DiGirolamo Bates, and I am the niece of John DiGirolamo. And I first want to thank the board, and I want to thank God for this opportunity. We have been praying and working for this for many, many years. So thank you for this opportunity. It's a blessing to us. I want to just explain a little bit about my uncle. He's a very emotional man. And so I know he's trying very hard right now to not be emotional. But I can tell you that not a day goes by that John does not express an incredible amount of remorse for his participation in that event so many years ago, with tearful agony of how sorry he is for the pain and the suffering that he participated in. I also want to let you know some other things about John. He's extremely important to our family. He is my only family. You had asked Mr. Freeman about our family, and John takes full accountability for his actions, and so it's his character not to put any blame on our family. But I will share with you that our family has a lot of corruption in the background, and I also ran away from home at the same age as John, and so that very well could have been me. My father was a heroin dealer. He died of a heroin overdose. My grandfather led a very violent life, and we were filled with a great deal of emotional and psychological abuse. And so I won't go belabor it. I will just say that it was a very difficult place to grow up. And again, I also ran away at the same time as John did, beat it many years later. He is a warm, kind, wise, funny, giving man, and a blessing to us. And I consider him a father figure to me. He was far more of a father than my father was. And my two daughters, who were not able to join because of the maximum, are both on YouTube watching, and he's very important to them too. And if he's able to come and live with our family, it will be a blessing. It will be such a blessing to me and our entire family. And as he mentioned, we live on a farm. We raise horses and cows, and we will take great care to support him. And then lastly, he mentioned his desire to participate in providing support to other kids at youth. I do this as well, and we are members and run multiple charitable organizations. I actually work in public health, public mental health, and we have plans for him to be able to support, children that are at risk, that come from homes similar to our upbringing, and to help to not only give them, a cautionary look at what life is based on young choices, but also to be able to support and guide them. And I know he's going to do a wonderful job at that.
Mr. Bates.
Yes. I guess when I met John several years ago through my wife, I was more skeptical. He's not my uncle. I wanted to meet him and talk with him. And I didn't go into it with a really open mind, to be honest with you. Because after all, he's in prison for life for murder, but as I got to know John and did some research on his case, met him multiple times in person, and I went there to kind of, like I said, pretty skeptical. But John has always taken responsibility for the part he played in that. He, like Shannon said, he's always shown a lot of remorse. And to be honest with you, there's been a lot of court hearings that we've been involved in for the whole release of the juvenile lifers, and the opposition always shows up. And that was always frustrating for me, being the business, we're trying to get things, and they would always show up, and he always would talk me down and say, look, you have to understand, I would probably do the same thing if I was in their shoes. And I always thought that was very big of him, considering, that they were a big part of keeping him in prison, even when the law seemed to be on his side. And, like Shannon said, we have plenty of room. We have the means to take care of John. I know he has physical ailments. If we get him past, he says he wants to do stuff. I don't know how much he can do on the farm, but believe me, we've got plenty to do if he can do it. And we also have plenty of community resources that we can lean on. Like Shannon said, she's very involved in the community mental health area and several nonprofits that we're involved in, and just friends that own businesses that we could get John a job at if he was capable physically. And I know nobody's brought this up, but John has been very active in church. I don't know how long that's been going on, but ever since I've known him, he's been very active in the church at prison. And I don't think it's just because he's trying to get out, because he's always been active in church at prison. And when we met John, he had no hope of getting out. So I do think that people change. And I do think that after what he say he was in there for 45 years in prison, if he's able to get out and we're able to offer him a level of support, I just don't see any reason why he can't make it. And we just appreciate the opportunity to do so, if you all would allow us.
All right, thank you much for your remarks. Now we'll hear from the opposition. Mr. Parks, I'll let you, I don't know how you want it, if you want the victim's family to speak first or you, I'll let you guide that for us.
You want to speak first? Whatever. Okay. I will go ahead and let the family of the victim speak first. And 1 second, let me reposition the screen.
Yeah, we just want to reiterate that there's a 3-minute limit on the remarks.
Okay. There's a 3-minute limit?
Each per person.
Okay. It seemed like the other parties speak for longer than 3 minutes.
No, I have time. That's okay. Go ahead.
All right. All right. Thank you.
How long do we have?
3 minutes each. 3 minutes per person.
She's gonna talk.
Okay. Yeah. Okay. All right, let's
My name is Gail Schlosser. And first, since I only have 3 minutes, let me reiterate the objection to this hearing that I outlined in my letter. I trust the board members have read it, and he's not eligible even to be before this hearing. This hearing's unlawful, and Act 4, because of his aggravated kidnapping conviction, specifically excludes him from taking advantage of Act 99, which is what he claims allows him to come before the board. And so along with my other objections in my letter, I wanted to point that out. So object to the hearing, object to his being found parole eligibility, and I certainly object to any chance of him getting parole. He is a flight risk. He's a danger to the community. He knows nothing but escape from authority. He has no respect for authority, and he defies authority. He will never report to parole. If he's given parole, he will abscond. The crimes he's been imprisoned with are all a result of his repeated attempts to escape from the police. He escaped from the New York drug rehab center, one escape. Came down to New Orleans, was spotted in a stolen car by New Orleans police. He led him on a high-speed chase because he had to escape from the New Orleans police. He ends up in City Park, loses that car, and abducts Rochelle and her boyfriend to get her car to further escape from the police who were on his tail. Ends up in the Wrigley's, that car blows up. He are now on foot, they have to escape, which make Rochelle and her boyfriend more burdensome, so they shot him to continue their escape. There was a 3-day manhunt with helicopters, dogs, and everything. They keep They kept eluding the police all over a possession of a stolen vehicle. That's all he knows is to escape. He's an escape artist. When he was finally caught and put in St. Tammany Parish Jail, he escaped there. Broke his leg. It's the only reason he was caught. He hasn't complied with, he hasn't been followed the rules in Angola. Angola's had a hard time keeping control of him. He'll never report to parole if he's unleashed on society. I fear for the danger of the community. I fear for the danger of the family. I feel for the danger of y'all and your loved ones. And I pray that God leads you to make the right decision to keep the community safe. Don't let his health claims fool you. He was seen walking down the hallway, swinging his walker until he got to the courtroom, and then put his walker in front of him, limping inside the courtroom. He exaggerates his effect of his health.
Need to move on. We appreciate your remark.
Thank you.
Yeah.
Good afternoon, members of the Parole Board and all of those attending the hearing. My name is Renee Reese Garrett. Rochelle Ann Reese, the victim of this murder, was my older sister, my best friend, my babysitter, my tutor, my biggest cheerleader, and the future matriarch of our family. Prior to this hearing, I sent a letter to the board outlining the impact this murder has had on my life. I hope all of the members of the board took the opportunity to read it. I would like to reiterate the fact that this hearing is unlawful since this murderer, John DiGirolamo, is ineligible for a parole hearing. He has never been eligible for a hearing. That hasn't stopped him from repeatedly trying to escape responsibility for his actions, though. In fact, this criminal has spent a lifetime of trying to escape punishment for his actions. Before my sister's murder, a sympathetic judge sentenced this heinous criminal to a drug rehabilitation center instead of giving him jail time. DiGirolamo escaped that rehabilitation center, stole a Mercedes, and drove to New Orleans, where he once again eluded capture repeatedly before murdering my sister, Rochelle. While remanded to the St. Tammany jail after finally being arrested, DiGirolamo attempted escape from the dilapidated jail and would have succeeded had he not broken his leg in the process. Instead of being charged with that crime, he was given further relief when the St. Tammany District Attorney, Marion Farmer, plea bargained the case, allowing this murderer to escape the death penalty. Part of that plea bargain, however, included DiGirolamo's inability to ever seek parole. The plea bargain, which DiGirolamo agreed to, has not stopped him from trying to gain release many times over the years. Every time my family has been there to state our objection to his release, how many more times do we need to be present and object? I would like to state for the record the result of the last hearing granted to this criminal on May 18th, 2018. At that hearing, the Louisiana Supreme Court unanimously ruled that this heinous criminal is ineligible for parole. If this menace to society is allowed to go free, he will undoubtedly revert to the only skills he has ever obtained, which are murder and robbery. As the members of the board, I implore you to uphold the rule of law and deny this heinous murderer parole. Thank you for your time.
Good morning to the parole board and to all of you participating in this Zoom call. I'm Aisha Reese, the mother of Rochelle Ann Reese, who was brutally murdered by this incorrigible criminal, John DiGirolamo. This isn't part of my speech, but after listening to what he just said, it is all a lie. He is not taking responsibility for anything he's done. I'm not accepting his so-called apology. He's a liar about all of it. He's we had an eyewitness to this crime, and none of it is what he said. But let me go on to say, this hearing is unlawful, unconstitutional, and I feel it's rigged. Because when I spoke with the executive director of the parole board, Francis Abbott, I was told that this is a done deal. How is that possible when the hearing hasn't even taken place? In spite of Mr. Abbott's proclamation, we decided to come today to speak to you, the board members. We feel it is up to you, the board members, to make the determination. John DiGirolamo has ruined the lives of our family and our friends. Now he is asking mercy from the court system that he mocked, as he and his accomplice laughed through every court appearance over the years. My husband and I witnessed this from day one. In fact, I have written a book with names, dates, and pictures. This case is astonishing. I can assure you, each and every one who is involved in this unbelievable case will be given full credit for their contributions or lack thereof, to be continued. I will not repeat this incorrigible criminal's name over and over, but will refer to him as JD. JD has been given 4 consecutive sentences equating to 229 years. We were assured he would serve this time and never be able to get out because they are consecutive sentences with no possibility of parole. We were assured of this by our inept DA, Marion Farmer, who had never tried a capital case when he entered office. Therefore, he plea bargained this case. It was an open and shut case that would have brought the death penalty from any experienced DA. He stated this would be far better than the death penalty because that is so often overturned. JD eagerly accepted this sentence and was in order to escape the death penalty. Instead, my family and I have been sentenced as well by having to appear in court every time JD finds a loophole for his anticipated escape. One of the biggest problems is that JD is a flight risk because he will never show up to check in with his parole officer. I know this because he escaped from a drug rehab center in New York, stole a Mercedes, drove to New Orleans, and it was his idea to do that when he murdered my daughter. It was not Polizzi. He was the one that organized all of it. Then after the murder, when in Covington jail, he tried again to escape, breaking his leg, which is still giving him a problem today. JD has not changed one bit since, yes.
We do have the information that you provided to us in the binder. So could you wrap it up for us, please?
Yes. You know, they were given all the time they needed. I would like to state my case, if you don't mind.
So, ma'am, we have on a time limit here. We do have your written information that's in the record, and I did have a timer on as well.
Well, you might want to consider that Dr. Bloom tested before he entered Angola. Dr. Bloom stated that JD was the most dangerous individual he had ever tested in his career. He has not changed. After arriving at Angola, Dr. Harris reported JD had antisocial tendencies. JD lives by a kill or be killed attitude. He is resentful of all authority. That has not changed. The only way they punish him in Angola, and everybody knows he's the worst of the worst, they put him in a hole. Now, where is that going to be done on the outside? He's a threat to the community. He's never done anything for anyone else, not even himself. If he and his accomplice had been punished for the crimes they committed, starting as early as 9 years old, and he himself testified earlier that his father gave him beer when he was 6 years old, and he does drugs. He has done drugs since he was a child. It's all in his record. He can lie about it if he wishes. It is a lie. If they
Yes,
had been
ma'am.
given
Reese,
time,
wrap it up. Please. You're at 6 minutes. Wrap it up.
I will say, I will end by saying that I have the document from the Department of Public Safety and Corrections sent to me April 13th, 2018, stating that JD's parole date is April 6, 2070. He was given a pine box sentence, and my family and I expect that to remain. If you or your loved one who tried to comply with the wishes of these two vile beings, instead of being released as promised, they were walked into a swamp filled with insects and alligators and shot at close.
All right, thank you, ma'am. Ms. Reese, we have to conclude and we'll move on to Mr. Clark's. Go ahead, sir. Mr. Clark's. I apologize.
Yes, ma'am. First of all, what I would like to say is, I must say, well, first of all, for the reasons stated by Ms. Schlosser earlier, the state is also, or at least the St. Tammany District Attorney's Office is also lodging an objection as to the commencement of this parole hearing. Having said that, I must admit I'm a bit confused from everything I've heard, because the papers and the documents I have in front of me completely contradict everything we've heard today. Now, first of all, what we've heard is a very cold, calculated, and absolutely emotionless statement coming from a person who, once you read the facts of this case, you see is nothing less than the personification of evil itself. This individual has said that he is just laying around, not doing much. Of course, in his laying around, let me point out, he had no time to take any victim awareness courses. Instead, comes up with an excuse that he wasn't in for a sex offense. So he makes that excuse. However, he did have time for 93 write-ups going from 1980 all the way up to 2020. I will note, and this is just a summation of them, from 2003 to 2016, aggravated disobedience, defiance, aggravated disobedience, contraband, aggravated work offenses, aggravated disobedience, intoxication, aggravated work offenses, aggravated disobedience. This doesn't sound like a person who is just sitting around and doing nothing. This is not a person who, as they claim, has turned their life around. Apparently, he has had his substance abuse treatment waived in this case for whatever reason. However, we do know by his own admission, although he has lied in this very hearing, that he was in possession of a narcotic while he's actually in prison not too many years ago. If memory serves, I want to say it was 2018 that he was actually in possession of a narcotic. So I do not understand exactly why that's been waived for him. We've been told that he cannot participate in the literacy or cannot get his GED because of his learning disabilities. However, now today, for the first time, it's been learned that he's in a literacy program, which has been an amazing development now that he is now in a literacy program. Now, furthermore, he also says that he has no ability to work, that he is disabled, yet his re-entry plan is to work on a farm. I find it extremely difficult to understand exactly how he plans on working on a farm with animals when, by his same words, he can't work, he can't do anything, he's limited to a wheelchair or a walker at best. Furthermore, as far as him taking responsibility, I will note that nowhere in the pre-parole report does he ever admit any responsibility. There's not one word of sorry, remorse, regret, nothing. There was absolutely nothing in this report. Today, for the first day, does he decide to come in and give a very cold, calculated apology, which has, in my opinion, zero to no weight whatsoever. It is nothing more than a script. It could have been a teleprompter in front and reading from a teleprompter. We have nothing in this report, absolutely nothing to show that. What we do have, though, as stated earlier, is the fact that even while in prison, he is still up to 2020 still committing offenses regularly, and not just regular offenses. We are looking at aggravated offenses that are being committed in this case. I don't see remorse. I don't see a person who has, quote, changed their life and grown up. As someone who's grown up committing aggravated disobedience, if he's committing disobedience in a jail, defiance in a prison in Angola, what's to stop him from being defiant with a parole officer? What's to stop him from being defiant anywhere? What's to stop him with his history of absconding from fleeing, going to Houston, Texas, and he being close to an international border and fleeing, leaving completely? There's absolutely nothing to stop him. It goes without saying that this crime is probably one of the most heinous I've seen, given the fact that we have the execution of two people lying face down in a swamp. Why? Well, Mr. DiGirolamo told you why in his statement. They didn't know what to do with him. So the best idea was to shoot each of them 4 times with a shotgun while they're laying face down. He just didn't know what to do with them. Cold, remorseless, and absolutely calculating. The judges in these cases sentenced him to consecutive sentence for a reason. They realized he is the absolute worst of the worst, a person who does not ever deserve to see the light of day outside of a prison for the acts that he's committed. And with that, I will turn to Miss Andrew with the AG's office.
Good morning, Madam Chairperson. First of all, our objection is based on the heinous nature of the crime and the inmate's lack of remorse and rehabilitation, and not to belabor the objections to the hearing itself. But I do want to point out to the board that the inmate was convicted of aggravated kidnapping and is serving a life sentence for that crime. He went, and so I think we're confused as to why he is here based on the aggravated kidnapping. He was granted a Miller-Montgomery hearing in Orleans Parish on the aggravated kidnapping. It was before Honorable Karen Herman. After she heard the evidence, she did not grant the inmate parole eligibility. So we're a bit confused as to why he's here on that crime alone. And I would note, although the record shows that Judge Herman has objected or has opposed, early release for this particular inmate. I'm sure this panel appreciates how rare it is for a judge to take these measures. I think the panel will appreciate that judges often don't take a position on these cases, but this judge is emphatic. She found him to be the worst of the worst after the hearing, and she maintains that he should not be released. The panel, the board is well aware of the heinous nature of the crimes. The kidnapping, it's always baffled me as to why. I understand that this inmate stole a car from New York. Then he stole the car from these 2 young people, but why he took them, he's never explained that. And it's just been a morbid curiosity on my part. The board is aware he took them to, although he today tries to place the blame on the person who's not here today, the person who was his co-defendant at trial. But I'm hoping that the board knows better. He took quite an active part in all of these actions. But the 2 were essentially executed. I'd also like to point out that the surviving victim committed suicide some years later. I don't know if the board is aware of that, and I don't think we have to guess. Based on the torment that the victims here before you today have experienced, we can more than guess that these events had some bearing on his having committed suicide. So the heinous nature of the crime, the execution style, this crime rivals Truman Capote's in cold blood, rivals the Manson murders. I can't imagine a worse set of, or more heinous set of facts. We don't see where this inmate has been granted every opportunity to better himself and to show in his report to this panel that he has bettered himself. I mean, really, after all of these years, the fact that he's completed 6 months of groundskeeping and 100 hours here, 100 hours there, and most importantly, didn't take it upon himself to educate himself as to what he has done to victims. Again, he's blaming his co-defendant. Now he's blaming the DOC or the penitentiary for not telling him that he needed to be educated in just what he has done to several people on this earth. So he still blames his robotic, apparently rehearsed statement before this court. Before this panel, he uses the word mistake. This was not a mistake. He says that these were acts of a rebellious teen. These are not the acts of a rebellious teen. These are not acts of a mistake. His own niece is proof that you can be raised in the worst even of circumstances and not commit crimes the way this inmate committed crimes. So based on the heinous nature of the crime, his lack of remorse and his lack of attempts to rehabilitate himself are the basis of the Attorney General's opposition today.
We need their names.
All right. Before I turn it over to Ms. Hogan, Mr. DiGirolamo, is there a statement you'd like to make briefly to the panel?
Yes, I would like to say that I'm very deeply sorry for the crime I was involved in. I would like to point out that the guy that I was with was several years older than I was. I never once touched the gun, ever. He wouldn't let me touch it, or did I drive the car. He said I was too young. My fall partner is older than me, and I do take responsibility for the actions that took place of the crime. I am very, very, very sorry for the crimes I was involved in and I committed. Those are crimes I live with every day. I do feel bad, and I'm very sorry for what happened. If it was up to me, I would change everything all over again. I'm not what you call a reject to society. I have learned to be responsible, a loving person. I am very sorry for the crime I was involved in and the crimes that I committed. I am very, very sorry.
Yes, sir. Thank you. Ms. Hogan.
Thank you, Ms. Renatza. I would like to just first clarify something. Mr. DiGirolamo has never had a Miller Montgomery hearing. There's never been a judicial finding that he's the worst of the worst. He had a 50-year sentence, a 99-year sentence, life with parole after 40 for the second-degree murder, and life without parole for the aggravated kidnapping. The district attorney in St. Tammany Parish stipulated that he was parole eligible under Act 280 for life with parole for the second-degree murder. And he has independent parole eligibility pursuant to Graham 15-574-4D on the aggravated kidnapping because he was 17 years old at the time of the crime. The issue was that all of his sentences were running consecutively. So even though he had parole eligibility independently on each charge, he had no parole date for a while until the passage of Act 99 and until there was actually a judicial review there was a petition for judicial review in the 19th JDC in 2019, in which the Department of Corrections stipulated that Mr. DiGirolamo is parole eligible pursuant to Act 99. So I wanted to clear that up. He's never had a Miller Montgomery hearing. He's never had full mitigation workup. There's never been any judge saying that he is the worst of the worst. That has never happened. Mr. DiGirolamo is not the worst of the worst. He was 17 years old. There's no doubt that this was a horrific, unnecessary act of violence that he participated in directly. He is just as culpable as his co-defendant, who was several years older, but it is also undisputed that the person who held the gun and did the shooting that night was not Mr. DiGirolamo. And Mr. DiGirolamo's fall partner, Vincent Police, remains in prison with no avenue for relief because he was not a juvenile at the time of. Over the last 43 years, Mr. DiGirolamo has changed dramatically. He has a significant decrease in the number of write-ups that he's received. He hasn't had any write-ups in 2 years. In the last 12 years, he's only had 10 write-ups. He is a regular attendant of church. He's taken classes where he could. He has limited abilities cognitively and physically. In 2016, as long as I've known him, I've been working on this case since 2016. He has had a no duty status, so he is ineligible to do much work. He's in a medical dorm right now. So although this is unquestionably a very difficult case, there is an ideal opportunity to release Mr. DiGirolamo at this moment because he has his interstate parole agreement has already been approved to Texas. He has a loving family with a large horse farm that is going to take complete responsibility for him financially, emotionally, and everything else. If the board wants him to get a mental health evaluation or a substance abuse evaluation, the Bates are more than able to arrange that. The Bates are personally vouching for him. They will personally make sure that he checks in with his parole officer, that he follows all the rules. Mr. DiGirolamo has no desire to even get a driver's license. He wants to get out, live with his family, and just spend his remaining days with them. Given his health, the fact that he's had 2 strokes recently, that he's at risk for more strokes, and that there is an approved interstate parole agreement to Texas, and that he has a low risk assessment, which is an objective measure of his likelihood of reoffending, I would ask this board to grant him release to Texas with any conditions that it deems appropriate. Thank you.
Okay, I think that concludes our proceedings. So the board will be voting, and we'll start with Mr. Freeman.
Okay, this is a very, very difficult case. Probably the hardest I've had since I've been on here. We have a guy that's been in prison for 45 years and 17 years old at the time committed his crime, but he also committed a very, very horrific crime that has definitely affected the family and all of the victims have been tremendously affected. He has great family support. The Bates, I appreciate y'all stepping up. I couldn't think of a better place for him than on a horse farm. So my vote today is going to be to grant his parole, where he is to go straight to Texas, and that he is to wear an electronic monitoring device while in Texas. You may have to pay for that yourself. I don't know Texas rules. Louisiana, we would pay for it. But if you leave that horse ranch without permission of your parole officer, we will bring you right back here and put you right back in Angola. So that is my recommendation and my vote today.
Thank you, Mr. Freeman. Mr. Roche?
Mr. DiGeronimo, good morning.
Good morning.
Yeah, one of the only good thing I heard this morning is that you're finally in literacy program. How long have you been in the literacy program?
Almost 7 months.
And how far along are you?
I went up on my grades on the last tape test. I have a lot of difficulty remembering what is taught to me because of the 2 strokes I had late last year.
But I'd like to see you continue that program. Because maybe one day you can work on a concept degree. Mr. DiGeronimo, your disciplinary conduct over a period of 43 years is unacceptable. You have 18 contraband repeatedly over the last 43 years. You have taken contraband and had things that you were not supposed to have. You have at least 11 fights or aggravated fights. You have 17 aggravated disobedience. You have an addiction to gambling. You've been cited and written up at least 10 times for gambling, 7 or 8 times for aggravated work offense, 5 or 6 times for defiance. You've been either in extended lockdown or the working cell block 15 or 20 times over a period of 43 years. I think you need some additional programming. The entire legal community is opposed to this early release. You have a fair institutional record, and I know why it's fair, simply because you have a terrible disciplinary history, and the family of your victim, they are adamantly opposed to any early release. For all those reasons, I'm going to deny your request this morning.
Mr. DiGeronimo, first, I just want to thank everybody who's participated today. Hearing from both sides was very, very important. You know, I when I looked at your record, I wanted to see when you started working on you. I don't believe that you were denied victim awareness like you said you were, because you're not a sex offender. But it doesn't, to me, it seems to me that you started working on you probably when Ms. Hogan got involved in your case, because the earliest I see classes that you've taken advantage of was 2016. So that's probably about the time you knew you might be eligible for parole. So for me, I'd like to see, and I do see that you had anger management and thinking for change, but I do believe you need a little more programming to, particularly victim awareness, to better prepare you. So my vote today also is to deny. I would encourage you to take advantage of program opportunities. Because you have a no duty status, I'm sure you'll be able to participate in those programs. And then I would encourage you to write back once you get some of those under your belt. So you received 1 favorable vote, 2 votes, 1 vote to deny, 1 vote, another to deny, with encouragement to take advantage of programs and write back. Today, your parole's been denied, sir. Good luck to you.
Thank you.
Wow. So how do we unpack this? Where do I start? I think I'll start with Mr. O'Shea's kind of mic drop, like a passive aggressive mic drop. when he jumped in. And what did he say? He said, like, the only good thing in this hearing this morning was that you started to participate in literacy programs. and and he says, I think that's really good because, and then, one day you'll be able to work on your GED. And I thought at that point that was like just classic Mr. O'Shea. Before he then went into his montage about how terrible his record was. The next thing I want to address is Miss Renatza putting a clock on the victims. It's really unbelievable. I went back and I timed all of the speakers. And the niece, the first speaker that spoke, she spoke for 4 minutes and 30 seconds, give or take a few seconds. 4 minutes and 30 seconds. So as Brian Clark, the ADA, said, yeah, they did get more time. Now, her husband, Danny, I think it's her husband, he spoke for 3 minutes and 20 seconds. But then when let's see, Brian Clark, I think, spoke for 3 minutes and 15 seconds. Then the victim spoke for 2 minutes and 40 seconds. And the final victim spoke for, when she hit 4 minutes, Miss Renatza told her to stop talking. And then she went on for another minute before she actually cut her off. But the idea that the victim, the niece, could speak for 4 minutes and 30 seconds without being told to stop talking, and the victim's own mother gets 30 seconds left before she's told to stop, is disgusting. And the other victim spoke for 3 minutes and 15 seconds, before Miss Renatza cut her off. So she got a full minute and 15 seconds less than the niece. And that's just messed up. That is messed up. I get you got to put time on it, but she was like, and the way that you say things, wrap it up, it's like, come on. It's not that difficult to use different language. You can say, I am so sorry. We understand this and this and this. But even then, she simply gave more time to the niece, to hear the niece talk about all these things. And what were the words that she even said? The niece said that he is in tearful agony over what he's done. And that's just, I'll just say it. That's just BS. We saw the only tears he had was for himself. He was, like Brian Clark, the ADA, said, reading from a teleprompter. Richard put in the notes, someone makes a surprise at the parole hearing, and I'm thinking, who made a surprise? And then when I saw Brian Clark, I said, okay, we've seen him a few times, and I got to tell you, we've seen him. He did at one hearing where he went nuts at the parole board because Miss Jackson insulted him about the Vietnam War, saying he doesn't understand. And I thought Miss Jackson was right in that case, and Brian Clark was wrong. He basically wanted to keep this Vietnam War veteran locked up. And Brian Clark, I think, is like one of those people on your sports team. You're happy when he's on your team, but if you're playing against him, you despise him, and the whole league despises him, and the announcers despise him. But if he's on your team, you're happy that he's there. And I feel like that it just seems that he's one of the victims. He's passionate about it. He's animated. He feels it. You can just feel it. And it's just great to see that like this is how every case should be. You have not only the ADA, but you have the attorney general showed up. Now, I didn't think she did a good job. I thought it was anticlimactic after hearing the prior 4 statements. She was kind of just going through it. But hey, I mean, I guess it's hard to follow up from all those acts. Something else. But I mean, Brian Clark, he laid out I thought it was just brilliant, stating each point. And then you follow up with Jane Hogan, and I'm not a fan of Jane Hogan because I'm not a fan of the Parole Project, and I just don't know how she gets up there and does her thing all the time. But I do have to, I think, give her credit. I thought she did as good of a job as she could have, bringing up all the case laws, stating the, I guess, fact from fiction when it came to his eligibility and all of these acts, right? It seems like he had this act, he had act, and then I don't know, like 3 different acts, and then Act 99. Act 99 is, I believe, the act that where they found it unconstitutional to have someone locked up under the age of 18. And that's what made him finally eligible for parole, right? This isn't a commutation sentence. This isn't something that needs to be approved from the governor. This is just straight up parole. And he is going to be able to continue to apply. And I know he looks, a bit weird for tears, so to speak. There might be an understatement, but he's relatively young. He's 62 today. He just looks like crap. Pardon my language, but I mean, maybe I take that back. He just doesn't look as he looks like, he looks, I don't know, I would say 20 years older than that. 62, you got a lot. You got the whole those are supposed to be your, what are they called? Years. Out living on a horse farm, which was interesting. I was surprised Mr. Freeman, I was surprised Mr. Renata said no, actually. I thought she was going to say yes, but she did not. I thought when as soon as Mr. Freeman voted yes, I thought he was going to get the 2-3 vote. Now, we do have some information I'll read for you about this case. We don't have appeals, which is quite strange. You would think for this case we'd have loads of appeals, but we don't. And again, I guess that's because of the plea deal. And isn't that interesting how they mentioned how that ADA never had done a capital case, and just said, hey, do the plea deal because these things get overturned anyways. And the family feels so betrayed by that. So I'm just going to read it from what Richard shared with me. And basically he shared it in like regular text. So I'm going to read it. 2 teenagers arrested at a Slidell motel have been booked with murder and attempted murder of a young couple kidnapped from New Orleans Park and blasted with a shotgun. St. Tammany Parish Sheriff's Department said Johnny DiGirolamo, 17 of Yonkers, New York, and Vincent Palizzi, 18 of Parksville, New York, were arrested Tuesday without incident. Oh, and on that note, John DiGirolamo and how, that I thought that was so tasteless. But everything with the Parole Project to me is tasteless now. But when Andrew Hunley came in and he's like, oh, haha, none of us could pronounce his name, so we called him Geronimo. For those of you who might not know, Andrew is locked up for a horrific crime himself, and he got out on the Juvenile Act as well. So they arrested with that incident. The two are believed to be implicated in New York holdup and auto theft over the weekend before they made their way to New Orleans in a stolen 1977 Mercedes. So they did a holdup. They stole a car. A sheriff spokesman said the men were traced to Slidell Motel 30 miles east of New Orleans on the other side of Lake Pontchartrain. I know I butchered that. John Chantry, 19 of River Ridge in Jefferson Parish, was wounded, and his companion, Rochelle Reese, 18, also of River Ridge, was killed. Chantrine underwent surgery for bullet wounds in the stomach and thigh Thursday and was reported in stable condition. The young couple apparently was abducted Sunday night from City Park, driven in Miss Reese's cars to the Slidell area and forced out when the car broke down. The girl was killed and Chantry apparently left for dead. St. Tammany deputies were called to the area after a couple at a fishing camp reported hearing several gunshots. As officers arrived, the headlights of their cars picked up a man crawling across the highway. Oh my gosh. He was crying, "They shot me, they shot me." It was Chantry. Officers followed his trail of blood and discovered the body of Miss Reese about 100 yards off the side of the highway on the edge of the ankle-deep marsh. Chantry told the officers he pretended to be dead, and as he lay near the girl, waited for the gunman to leave and then crawled out. Officers speculated the arrested men were the same two who were tailed through the French Quarter when police patrol spotted two men in Mercedes acting suspicious Sunday night. The car was locked in traffic. That is so sad. The police saw them and lost them in traffic. This all could have been avoided. Wow. That makes this extra tragic. Later, the police found the vehicle abandoned near City Park with a tire blown out. The car also had been blasted with a shotgun. A witness told police he saw two men firing at it. Police could give no explanation for the shooting of the vehicle. A cheek of the car's license plate showed it had been reported stolen in New York on Saturday. The men wanted for the car theft were also wanted in the armed robbery of a gas station in Mount Vernon, New York. Police in New Orleans also have filed charges of aggravated kidnapping against the pair. I mean, like, they went from New York all the way to Louisiana. It's like, why? And then, again, like, and this was brought up by the Attorney General, all they needed was a car. Why did they kidnap them? And you can only imagine. Slidell, what their intentions were. Slidell Authority Tuesday arrested two New York teenagers at a local. This is now another article. This is arrested two New York teenagers at a local motel and charged them with the slaying of a River Ridge girl and the shooting of her companion. How do you survive a shotgun blast? It's absolutely surprising. I think it's like the lowest survivability rate of any, like, New Orleans FBI and Louisiana State Police moved the suspect's motel room at 12:09 p.m. and arrested John Geronimo, 17, of Yonkers, New York, and Vincent Pellicci, 18. And look at that too. And according to this newspaper, they're 1 year apart. In his final statement, where he showed no emotion, again reading like as if he was reading from a teleprompter, he's still trying to make it out. He was older than me. I was young. He wouldn't let me drive. He wouldn't let me hold a gun. Really, buddy? You want us to believe that you drove from New York to Louisiana and he was the only driver? Okay. Because you're 1 year apart? Okay. He didn't let you hold the gun? Okay. I don't believe a word this guy says, not a word. There is something wrong with him. There is something very wrong with him. And he loved the supporters. Like, was it the husband or, oh, he's such a good man. You know, whenever you hear the supporters of the victims talk, they always talk so gushingly about someone. It's like they have this own perceived idea of who this person is. To use the words, he's horrifically, what is it? He's in tearful agony. It's just made up. He's not in tearful agony. Like this, you can't imagine. There's no way that could be a way to describe him. An 18 of Parksville, New York, on charges of murder, attempted murder, and being the fugitive of New Orleans. And to think that the 17-year-old can get parole and the 18-year-old can't. The pair also faces 2 counts of aggravated kidnapping in New Orleans for allegedly forcing Rochelle Reese, 18, and her companion, John Chantry, 18, to drive them from City Park Sunday night to Louisiana-Mississippi line. The suspects were being held without bond. Ms. Reese Chantry were kidnapped from the park and forced to drive in their car to state line. Police said that when their car broke down, they were taken out to desolate marsh area and shot twice each. Miss Reese was pronounced dead. Chantry managed to crawl to road 300 feet and seek help. He was listed in stable condition Tuesday with gunshot wounds. They said there was a 3rd victim that took their life. That's what I'm confused about, right? Did they say there were 3 victims? Because they're only mentioning 2 here. He had the gunshot wounds to his hip and back. The sheriff's office refused to indicate that the suspects were wanted to charge in New York. And so the suspects were driving a stolen car that was used in Mount Vernon, New York, armed robbery on Saturday. Authors said the suspects were staying in a motel located about 10 miles from the place where the shooting occurred. He refused to say whether any weapons were found in the room or what. Okay. So there you have it. That's you see on one side just the pain, the raw pain from the victims being treated really just completely disrespectfully by Miss Renatza. And at least we had Mr. O'Shea to save the day with a mic drop moment. And the sad part is that he's going to keep being able to apply for parole, and the family's going to keep having to go through this. And that's just heartbreaking. But thank you, Richard, for pointing these hearings out. And with that, I'll let you go.